Okay, we're going live on cause number DC 208020. This is our non-jury docket. We have two cases set. The first one is supposed to be very short. The other one's going to be a little longer or a lot longer. And so let's go ahead and go forward with the first case. Ms. Bromley, I believe you're the plaintiff's lawyer?
No, Your Honor, I'm actually for defendant.
Defendant's lawyer. Okay, Mr.
Yes.
Peterson, you're the plaintiff's lawyer? Is that correct?
Yes, sir. Thank you. Yes.
And go ahead and announce the case name, Mr. Peterson.
The case is First National Bank of Omaha versus Travis L. Abate.
All right, go ahead and begin with your opening statements.
Thank you, Your Honor. Again, my name is Eric Peterson. I'm here on behalf of the plaintiff. This is a very simple, probably a quick case. It's a debt case on a credit card. It's a collection on a credit card. The balance that we sued for is the charge-off amount, which is $10,797.25. That's the amount we're seeking, plus post-judgment interest and court costs. I have one exhibit. The only exhibit I have is the business records affidavit, which was filed, I believe, in October.
Have you emailed that to my court coordinator and my court reporter?
No, I have not. It's been filed.
Yeah, you need to email that to them if you want to introduce it as an exhibit.
I have it up here. I could. Is that Rhonda?
Rhonda and Tony
Okay.
Rieger.
Okay.
Do you have their email addresses?
I have Rhonda's, but I don't have Tony's.
Just go ahead and email Rhonda. And Rhonda, if you could email Tony.
Okay.
All right. Are you offering Exhibit 1?
Yes, Your Honor.
Any objection to Exhibit 1, Ms. Bromley?
No objection, Your Honor.
Exhibit 1 is admitted.
Thank
All right.
you.
Let me hear the defendant's opening statement.
Thank you, Your Honor. We are of the position that the business records as tendered to the court don't show that the the plaintiff ever accelerated the balance and made a demand for payment in full. Last statement included in the business records shows the amount due as $1246. I don't show a charge-off statement showing that the plaintiff ever liquidated their damages and made a demand for payment. So we would just ask that damages be limited to what they can actually prove up in court as liquidated damages.
Can you share screen what you're talking about?
Let me see.
I'm doing this from my phone, so unfortunately, I can't.
Let me see if it'll let me. It doesn't appear that I'm able to either, Your Honor.
Oh, I'm sorry. I need to enable it. I apologize. Let's see. Go ahead.
Let's see. Let's see if this is the right one. So we're looking at the final statement here that's dated January 9th of 2020.
Okay. And the
and
balance is
says-
10,000.
Balance is 10,797.25, but it says minimum payment due 1246, past due amount 928, and that's the last statement allegedly that our client, the defendant, would have received. So it's our position that perhaps the plaintiff never made a demand for payment in full.
Okay. All righty. Let's call your first witness. Plaintiffs.
Your Honor, the only evidence I have is that business records affidavit, which is it authenticates the documents that we provided, which I did just email to Rhonda. So I don't have a live witness.
Okay. Do you rest?
Yes, I do.
Defendants, call your first witness.
No witnesses, Your Honor.
Closing arguments, plaintiff.
Thank you, Your Honor. So the business records affidavit authenticates the documents, which are the account statements attached to it, which, as indicated to the court, does show a balance, a charge-off balance of $10,797.25, which is the amount that we sued for. No interest has accrued since that time. That was the
Mr.
final.
Peterson, are you still there?
Yes. Can you hear me?
You cut out for a second there. Say that
Okay.
again.
I'm sorry. So the records attached to the affidavit are my client's business records affidavit or business records, which do show an ending balance as indicated, $10,797.25. That was the amount listed on the final billing statement, which was the charge-off amount. There's been no interest or charges since then. That's the final amount, and that was the final demand made by my client. And that's the amount that we're seeking. Thank you.
Okay. What do you make of our argument that there wasn't a demand for payment or an acceleration?
Well, this isn't a loan; it's a credit card. So I don't know that a demand for acceleration is relevant or how it would apply. The demand is the account statement. I mean, every month you get a bill, and that's a demand for payment.
Okay, Ms. Bromling, it's your closing.
Briefly, Your Honor, just it's our position that we don't have a charge-off statement in the evidence that's before the court, and it's our position that there never was an acceleration of the balance and a demand for payment on the entire amount that they're showing as the balance on the account, and therefore their damages would be limited because they haven't liquidated their damages and made a demand for payment in full.
I have to be honest, I've never heard that argument made in context of a credit card case. So at this point, I'm going to grant judgment in favor of the plaintiff. If you want to brief that issue, I've never heard anyone make the argument. Maybe you're right, and I just no one has made the argument. But if you want to brief the issue with the judgment or as a new trial or whatever, I'm glad to hear it. I think it's an interesting argument. I don't think that's the law when it comes to credit cards. But if you know, I've been wrong before, so if you want to correct me, I'll be glad to hear it. So
okay, thank you, Your Honor. I appreciate the opportunity, and I will certainly confer with my co-counsel and see if that's something we're interested in doing. Maybe we will set new precedent.
that'd be great. That'd be great.
Okay.
Not for me.
Okay. Did you already submit a proposed judgment, Mr. Peterson?
No, but I can.
Go ahead and email Rhonda a proposed judgment. Share it with Ms. Bromley first. Rhonda's my court coordinator. Email her the proposed judgment, and then I'll try to get that signed as soon as possible.
Okay.
Thank you, Your Honor. One last closing issue,
Sure.
Your Honor. I wasn't clear from the petition if plaintiff was seeking attorney's fees, but I don't believe there was any testimony put on for attorney's fees.
There is no attorney's fees. They didn't
Okay.
present any evidence of it.
Okay. Thank you, Your Honor.
Thank you.
All right.
Thank
Have a
you,
good day.
guys. Okay.
Thank you.
You too. Thanks. Bye.
Okay, I think we're down to the Zatoon case. Is everyone here for that? Okay, so Ms. Pettit, Mr. Scott. Okay, so we're going to go ahead and start off. Give me the new cause number on this.
Sure, Your Honor. It's DC 20-18633.
All right, I just want to deal with a quick logistics issue, or maybe not logistics issue, but just a quick question. So I set for trial the other cause number. I guess this is the correct cause number that you just gave me. Is anyone objecting to going forward today with trial given that issue?
Your Honor, Julie Pettit speaking on behalf of the defendants. We don't object to it going forward on that particular issue. We do have two other pretrial motions, one involving the severance.
Okay.
I don't think that Your Honor is going to change your mind on the severance, but for the record, we do ask that we can present that to Your Honor and ask for a ruling.
Okay, that's no problem. Let's do this. Let's go ahead and deal with any pretrial issues and pre-admit exhibits, and then we'll start with opening statements. So does the plaintiff first have any pretrial issues or wish to pre-admit any exhibits?
Your Honor, with regard to pre-admitting exhibits, we've worked out a Rule 11 agreement with counsel that all of the exhibits on both sides be pre-admitted.
Okay, what are the exhibit numbers?
Your Honor, the exhibits on behalf of plaintiffs are exhibits 1 through 102, with the exception of a couple that they had omitted on their exhibit list. So their exhibit list as it is, we're agreeing to pre-admit everything on the list other than the ones that say omitted.
Ours are, Your Honor, 1 through 103, and theirs are
103, okay.
Okay, and theirs are 1 through 113, according to the pleading.
No, I show, and I can pull the Rule 11 agreement up. Ours are, plaintiffs are 1 through 102. And that is from their amended trial exhibit designation that was filed on January 3rd. Ours is the first amended list of trial exhibits. It's 1 through 116. That was filed on the 4th of January. And if needed, I can put up the Rule 11 agreement regarding those numbers.
I don't think we need to, Your Honor. Here's the clarification. Yesterday, for the first time, counsel produced to us what are represented to be the Versailles tax returns that Your Honor had ordered months and months ago. They're dated as of yesterday for 4 years worth of tax returns, unsigned, but that is our exhibit 103. And counsel had indicated that she had no objection to us adding those Versailles tax returns that we received from her.
Ms. Pettit, do you have any objection to what?
Sure. I have no objection to the tax returns.
Okay. All right,
But
so
I do want to be clear for the record that our list is exhibits 1 through 116 that are pre-admitted, not 1 through 113.
is that correct, Mr. Scott?
Yes, it is. I was looking at an earlier version. They've amended it. So yes, Your Honor, we've agreed. All the exhibits are coming in as evidence.
Okay, so 1 to 103 and then 1 to 116 are all admitted. Just so this is clear, have you emailed all of the exhibits and the exhibit list to Tony and to Rhonda?
Your Honor, we have emailed the exhibit list to Rhonda, not to Tony, but we will do that. But we also need to send the exhibit 103, that tax return that we just received, tax return exhibit that we just received yesterday.
Have you sent the actual exhibits to Tony, or how have you done that?
We have sent all of the exhibits, Your Honor, with hyperlinked, and we produced, so not to Tony, Your Honor, to Rhonda, because that's what we understood we were to do.
Ms. Pettit, have you sent the exhibits and the exhibit list to?
Ours have also been sent to Rhonda, not to Tony, though we can certainly do so.
Yeah, go ahead and send those. Tony, if you could just put your email address in the chat. And just go ahead and email those exhibit lists and exhibits to Tony. Okay. All right, Mr. Scott, that's great. I'm glad we got that all pre-admitted. Let's go ahead and then deal with the any pretrial issues that Mr. Scott, that you have.
Mr. Ackles will be arguing those for us.
Okay.
Well, I think this responds to some of her motions, which she filed a late, Ms. Pettit filed a late fourth amended answer on, I think, December 29th.
Are these motions that you're following, Mr. Ackles, or are you just responding to hers?
No, I think it's going to respond to hers, and I'll let her go first. It's fine, Your Honor.
Okay.
It addresses some of the issues she's going to raise in these two motions. So
Okay.
I'll defer to Ms. Pettit, and then I'll respond.
Great. Ms. Pettit, you have two motions?
Yes, Your Honor. First is the motion to strike severance and consolidate. Admittedly, I was not a part of the case when that happened, but based on my review of the record, what it appears happens is when Your Honor granted summary judgment dismissing my client's claim a proposed order was submitted to you that had a line at the bottom severing the cases. From what I can tell, that was never raised in front of Your Honor. There was never any briefing in that regard. There was never any argument in that regard that I can tell from the record. As we specify in our motion, because the claims are so intertwined, I don't believe that the claims should have been severed. Already it's caused some logistical issues, I would say, in regard to the two appeals going separately. As Your Honor can certainly understand, if let's assume that the Court of Appeals disagrees with Your Honor and does not think that our claims should have been dismissed, well, then Your Honor has already tried these claims, and it's all about the exact same home that's being built, the exact same building contract. They're just claims and counterclaims. So for purposes of certainly judicial economy and to make sure we don't get inconsistent results, we do believe that the severance should not have occurred. And again, I don't think it was actually raised, Your Honor. I think it was just a line that was included in a proposed order and wasn't actually specified why the severance should be taking place. Now, admittedly, the severance actually in some ways would be beneficial to my client because we get a head start on the appeal. But just realistically and logically, when you think about the situation, the severance doesn't make sense in a claim like this, in a case like this where the claims are so intertwined. And I think it's going to make the appeals potentially inconsistent and confusing. So for that reason, we would ask that the severance be undone and that the cases be tried together, even if that means that our claims are not tried today. And it all goes up on appeal together.
Response?
Your Honor, it's not uncommon for courts to do exactly what you did, which is to sever out claims that have been dismissed to make them final. And that's what happened in this case. And as per the usual, Ms. Pettis raising arguments that weren't presented to the court before. The proposed order with the severance language included in it.
Let me ask a first question. When was the severance finalized?
More than 75 days.
Yeah, would I even
before
have
they
plenary
filed-
jurisdiction to even do this on that case?
Your Honor, respectfully, we say no.
Your Honor, we
And they have already filed their notice of appeal from the final judgment, and the case
the
is
other
up on
case.
appeal. Correct, Your Honor.
Your Honor, we filed.
This is post-judgment and post-notice of appeal and post-docketing by the Fifth Court of Appeals of their case, which was on a discrete issue in any event. But we agree with regard to the question Your Honor raised. Yes, it's been long. It's more than 75 days after the final judgment was entered that they're making this motion.
Your Honor, two things. We filed this motion to strike severance in both of the cases. So certainly in this particular case, the DC 20 case, Your Honor has jurisdiction. And I believe the summary judgment order was signed. It's on the 75 days. It's going to be very close. Give me just 1 second. I want to confirm that date. I think it was October 29th, but 1 second.
And Julie, do you mind if I just
go ahead.
make a point? Your Honor, we filed a motion for new trial in connection to the summary judgment motion, which was denied less than 30 days ago. Your Honor still has plenary power.
Okay, I
for
didn't
30
know that. All right, that makes sense. So I probably do have plenary power. Yeah, I kind of think what's done is done. And I apologize if there's, to the Court of Appeals, I guess, if it's less convenient to do it this way, but I'm not going to undo it. I think it's that we're too far down the road. So what's the other issue?
Thank you, Your Honor. The next motion we filed, we actually filed this one this morning. It's an emergency motion to abate pursuant to the Residential Construction Liability Act. I'm sure Your Honor is already skeptical based on the timing of this, but if you'll allow me to give just a little bit of background and explain why this is being filed now. So as my client and I the last couple of days have been lamenting over the fact that a case like this shouldn't actually be going to trial. And even though we deny that we have any liability, it seems the builder should be able just to go in and fix any alleged issues with the house. As we were lamenting about that over the last couple of days, it hit me, wait a second, I think the Residential Construction Liability Act applies in this case. I know Your Honor is very familiar with the act. I believe I've had cases and maybe even a trial in your court on that exact act. And so in going back and looking at the act, it becomes clear that this case does fall squarely within the act. And what's so important about the Residential Construction Liability Act is that its stated purpose in the act is to encourage settlement between the parties. And the way that the act does that is it allows a builder like Versailles to go into a property where there's alleged defect. It allows Versailles to look at the property, inspect it, and say, you know what, we'll make you an offer. We'll make you an offer either to buy it back or to fix the defects, because maybe the defects, according to the builder, aren't that big of a deal. And what's happened in this case, we filed a verified motion to abate pursuant to the act this morning. What happened in this case is two things. First, there was a Rule 11 agreement that was filed with this court guaranteeing my client the right to inspect the property. That was filed by predecessor counsel of mine. It was filed with the court. It's also attached to our motion that said that my clients had the right to inspect the property. The inspector back in April of this year got COVID or was exposed to COVID or something like that. So that inspection didn't occur. And every single time since that date, when efforts have been made by my side to try to inspect the property so that my client can make an offer, those requests to inspect the property have been denied. Even since I've been involved, so I was hired sometime in November, I don't recall the exact date, but even since I've been involved, Your Honor, I have made 3 written attempts to opposing counsel saying, hey, we're trying to get this thing settled. Let my client in the house to inspect the property. And I've attached their responses. Each time they have refused to allow us to inspect the property. So that's, first of all, a violation of the Rule 11 agreement. We've cited, Your Honor, to authority, as Your Honor knows, that the court doesn't have discretion to deny the enforcement of a Rule 11 agreement. So that's one part. The second part is that the Residential Construction Liability Act also guarantees us the right to inspect the property. It says that a builder or a contractor in this position has the right, and there are certain deadlines that are very specific within the act, by which they should be allowed to inspect the property, make an offer, and if that offer is refused and it's a reasonable offer, then we have certain rights and remedies, and that's for a situation just like this. Further, Your Honor, section, I think, so the Residential Construction Liability Act is Chapter 27 of the Property Code, and it's section 41.00. 27.002, and then section section 004, part C, I messed that up. So 24.004, part C, talks about instances in which there's a counterclaim. So section C applies here because this is a counterclaim. My client sued first to collect on the debt, and they were hit with this counterclaim. So what section C does is also really important under the act. Section C says, when there's a counterclaim like this, the plaintiff, they're now the plaintiff, they were originally the defendant. So the Zatoons have to specifically plead every single construction defect. And again, that's for a case just like this to encourage settlement so that a builder knows what they're being accused of so that they have the right to fix it. Here, Your Honor, I've attached a highlighted version of their petition to my motion to abate to show you that over and over in their pleading, they specify again and again that there are construction defects in this house. But when you go through the petition, there is zero specificity. They don't even come close, Your Honor, to specifically pleading the defects that my client is being accused of. So not only is my client not informed pursuant to the petition and the RCLA what defects exist, but they're being denied their right to inspect the property and make an offer to these people to fix any alleged issues. Again, we stand behind the fact that based on the facts of this case, we shouldn't even have to do that. But my client at least has the right under the RCLA to do these things. As the court's familiar, the RCLA uses the word shall, that the court shall abate in instances where a builder is not.
This is catching me a little bit flat-footed. So I have the Texas Civil Practice and Remedies Code Plus here that has section 27 in it. So what provision are you relying on for the abatement?
It's the property code.
I'm sorry, I know, but the property code is in here, so it's 27.
Okay, so 27 of the property code. Our section, since this is a counterclaim, is section C. So if you go to 24.004.
24, 27.
So it's 27 of the property code. then section 27.004. And if you want me to share screen, if that's easier, I can do that.
No, I can. And then subsection C, it starts with in compliance with subtitle D,
Yes,
Title
Your Honor.
16.
Yes, Your Honor.
Okay.
Can you state that section again, please, Julie?
Sure. It is chapter 27 of the property code, section 27.004, and then subsection C is the part that applies to counterclaims.
Thank you.
And Your Honor, in subsection C, the most relevant and I think pointing part here is the fact that their complaint, it says shall specify in reasonable detail. And I can pull up their petition on the screen and show you that it is certainly a long petition, but nowhere in there do they name a single defect that they claim my clients have caused.
Well, there's a lot of deadlines in here. I just don't know. Let's see. Subtitle D, subtitle D, Title 16.
Sure, that, Your Honor, doesn't, I'll go ahead and let you know that does not apply in our case. There's certain provisions under Title D where if the parties originally in the case wanted to try and get an arbitration, they could have done so. So that subtitle D, Title 16 does not apply in this case.
So what sentence, I guess, are you relying on out of this?
So I'm relying on subsection C, which says that they must shall specify in reasonable detail each construction defect that is the subject of the complaint. And then part D, part A is all of the deadlines. Part A and B are the deadlines. Then part D says the court or arbitration tribunal shall abate an action governed by this chapter. If subsection C does not apply, and the court or tribunal after a hearing finds that the contractor is entitled to abatement because the claimant failed to comply with the requirements of that section, which doesn't apply, failed to provide the notice, or failed to give the contractor a reasonable opportunity to inspect the property. And again, our Rule 11 agreement, which is attached, specifies that we have the right to do this. This is all under the idea that this act is to encourage settlement. We're trying to get in the property. We don't think the defects, if any, are bad, and we believe they can be fixed. And the act gives us certain rights that if we agree to fix those and they deny us that right, we have remedies under the act. I also have the Dallas Court of Appeals has not interpreted the section when it's a counterclaim, so that makes ours just a little bit more complicated. However, there is one Texas case interpreting that provision. I want to say I can pull it up, but it's a little bit more clear than I would say the act itself is, if Your Honor would like to read an interpretation of a very, very similar fact pattern.
Okay.
Give me 1 second and I will pull it up.
Mr. Ackles, are you prepared to respond to this? I know this was filed at the last minute.
Yes, Your Honor, I am.
Okay.
Your Honor, we have an exhibit that we'd like to put up for Your Honor to look at.
Okay.
I'll do that in a minute, but I
Okay.
wanted to show the court the Rule 11 agreement that's attached to her, Ms. Pettit's motion to abate. And this Rule 11 agreement, is that before the court? Do you see that?
Is that what,
I just shared my, whoops, I somehow missed it.
yeah, is that I'm viewing Joe Ackle Senior's screen.
Yes, okay, so this Rule 11 agreement, for some reason when I'm trying to expand it, this is where they've waived all these things she's talking about. In April 10th, when this Rule 11 agreement was signed by all counsel, the parties agreed to move the trial date. The new deadline to designate responsive expert reports would be June 19th. We gave them an extension on their deadline to designate experts, and then they'll have to provide the report by July 17th. And then we extended the fact of the expert discovery deadline. But here on paragraph 2, the defendants will allow the plaintiffs and all the plaintiffs, the Alchamis and Versailles, to inspect the property at a mutual agreeable time and location no later than April 30th. This is what they proposed, and we agreed to, that we would extend the deadline for them to inspect the property till April 30th, and they chose that date. The defendants agreed to allow the plaintiff to have their experts and one lawyer from counsel present during the inspection. Plaintiff agrees to allow the defendants, along with the counsel, plaintiffs will identify the persons who will be present. The parties agree that the inspection will be conducted pursuant to 196.7. And then, so this is what we all agreed to. They would come in and inspect the property by April 30th. They chose not to do that, Your Honor. And then everything changed in this lawsuit. They, you know the litany of the May 30th hearing where you ordered them to produce all these documents that they've been holding. So then Miss Pettit, after this Rule 11 agreement, which is attached to her exhibit, and let me pick up the other.
Your Honor, I hate to interrupt, but before we leave that exhibit, I want to call Your Honor's attention to a second part that Mr. Ackles skipped over, which says that the plaintiff would allow a re-inspection if necessary. So COVID hit and the inspector couldn't go out on the 30th. But even says in paragraph 2, let's see, 4 lines up from the bottom, defendants will allow a re-inspection if necessary. We've been denied all of that.
That is a re-inspection, not the original inspection. This COVID hit thing is news to me, but the reality of it is that was our agreement. And then Ms. Pettit brings up this my December 5th email. That's settlement discussions. In the process of preparing for trial in December, they made us an offer, and that's something that shouldn't even be before the court. It's not admissible evidence. And as part of their offer, they said they wanted to inspect the property. And we said no, because we think that the fact that the defendants have agreed under the Rule 11 to inspect by April, never designated experts, never had experts disclosed in this case, don't have experts disclosed in this case. We felt, in the mistrust for these defendants, that they were simply trying to get back on the property so they could bring in a new expert. And then the exhibit Mr. Scott wanted to show the court is our expert's detailed report of the 50-page report of the defects on the property. They've had that report. Jonathan, can y'all put
it's right up here on the screen, Joe.
Okay, let me get out of my, there it is. I'm sorry, I was looking. Okay, this report has the great detail of every defect that we say is in the property. It was dated January 13th, 2020. They've had it for almost a year. And to say that they don't know what the defects are, this is a typical behavior of these defendants to try to delay, dodge. And so I submit, and this is what I wanted to say earlier, they've tried to add on December 29th, after this court set the file in amber for December 8th, on December 29th, they filed a 4th amended original answer. And that answer should not be allowed in this trial because it was filed too late. Today's they try to file it after the court set the case in amber. So we think that answer should be stricken. It superseded what is designated the 2nd amended answer that was filed previous to that. And it should have been called the 3rd amended answer. But anyway, the reality of it is, Judge, this is just the 11th hour effort on the part of the defendants to delay this trial yet once again. And Ms. Pettit, when she was hired, immediately filed for a motion for continuance, and they've done everything they can to delay the trial, and we just think we ought to be going forward, and this motion to abate should be denied.
Judge,
Let me just say this. I have to say this maybe is because this section is just really refers to a lot of other things that I'm not familiar with. I get this thing about the inspection. I really don't want to create an appeal point here on this. I do think it's kind of late to bring it up, and I'm not really sure what these deadlines, how they play in here.
Your Honor, would you like to see the case that I mentioned? I do.
Yeah,
think
why don't you do that?
this is the only case that we have found where it's discussing this in the context of the counterclaim, because that changes things.
Okay.
I'm trying to share my screen. Give me just one moment.
I think I have it enabled. Let me see.
It should be coming up now. And
Yeah.
so in this case, it's out of San Antonio, actually. In this particular case, when the court looks at the pleadings, they find that the homeowner in that case had sufficiently pled the defect. So this one ends differently than what I'm asking Your Honor to do. But I think the interpretation of the act was at least very helpful for me as I read it. Trying to zoom in, I know it's super small.
What's the site on that case, please?
Sure, it is, let me go back to the top. 131 Southwest 3rd, 94.
Thank you.
So Your Honor, I know it's on, I'm in control of the screen, so tell me when you want me to scroll.
Tell me what you want me to read.
Okay, if you go down to,
Okay, there it is. Okay, keep going down. Okay, go back up so I can see the next paragraph. So this is where I guess I'm coming into the question. It says both the inspection and the offer must be made within 60 days of the service of the counterclaim. Aren't we way past that?
we are, Your Honor, and our argument in that regard is the fact that we're being denied. The affidavit attached by my predecessor counsel makes it clear that he made multiple requests. Again, this is Mr. Suster, and his declaration is attached that he was making requests while he was talking to Mr. Ackles and Mr. Scott to inspect the property, and those were denied. And then as soon as I took over, I've made requests, and those are denied. So the bottom part of this page that Your Honor just read, or sorry, the top part, it says that we have to have reasonable opportunity to inspect and have inspected the property that's the subject of the complaint, and the opportunity to make a reasonable settlement offer. That's what we're trying to do, because the act allows us to make these types of offers and protect ourselves in situations like this when a reasonable offer is denied. So every step of the way, from original counsel to Mr. Suster to myself, we have not had the reasonable opportunity to inspect the property. We're not asking for a lot of time. We're asking for time for the builder to go in, see what's wrong, make an offer, and we'll agree to expedite that under the act and do it more quickly than required under the act. But we should at least have that opportunity so that we're protected if they refuse our reasonable offer.
Her case says it doesn't apply.
Joe, may I just add a few things? Your Honor, first of all, they're indicating that they've, and of course this was filed this morning, so I haven't had a full opportunity to review it, but I take counsel's representation at face value, of course, that that Mr. Suster is giving you an affidavit saying that he made oral requests to do an inspection to both myself and Mr. Ackles. I'll let Mr. Ackles respond to the allegation that requests were made to him. I want to represent to the court. During the time, the only request that we ever had during the course of this case to do an inspection was what is reflected in the Rule 11 agreement that was signed with Mr. Ertl at Glass Phillips, the first firm. And since that time, other than what counsel refers to as an improper settlement request, I have never received a request outside of settlement or whatsoever at all for Mr. Suster or his office to do a residential inspection of this property, or for Mr. Tyler. And you'll recall, Your Honor, that Mr. Suster is the same lawyer who submitted an affidavit to Your Honor in which he claimed that when he went on the record in open court and waived a jury trial for the clients, and you asked him whether or not all lawyers were authorized to do that, he told you that he was, and then they submitted an affidavit in which he denied that he did. So obviously he's a fellow member of the bar, but we have serious questions, and I think the court should, about the credibility of these kind of 11th hour assertions. I also want to mention, Your Honor, that counsel got a continuance on this case on the basis of a personal accommodation that she was getting married and for her honeymoon. And she represented to the court that it was not for purposes of delay and that she would not be doing anything to delay this trial setting. This motion to abate at the 12th hour is exactly that. One last point, Your Honor. Even if they're right, and we strenuously disagree as to their legal position, and we endorse the court's opinion or observation that this is way late, what they're raising in terms of the statute, it would not result or justify an abatement because only one of our causes of action is for construction defects and breach of contract. We have a fraudulent lien case here, Your Honor, as a cause of action. We have a federal racketeering case as a cause of action. So this authority has no application to any of those other causes of action. So there would be no basis to stop this trial. And Your Honor, we've been at this, as you know. They filed this case in October of 2018 and have pulled every maneuver imaginable to man and woman to delay this case. Oh, and I'm sorry, Your Honor, and one final thing. This was never raised in any of the pleadings that were filed in this case. They never raised that there was a condition precedent in terms of that we couldn't proceed with our causes of action on the basis of non-compliance with the Residential Construction Act. So we had no notice that they'd be raising this morning. And in fact, even if you look at the communications from counsel to Mr. Ackles from earlier in December, in no way did they say, we have the right to this inspection. It was a request in conjunction with evaluating or discussing settlement. So they never did it. The only time that there was a request, and we had litigation on this related to the inspection. We had filed a motion, Your Honor, that resulted in that Rule 11 to set conditions for the inspection. And then at the time they were the plaintiffs, they never contacted us and never made arrangements to do the inspection. And we've shown you the report from our primary construction expert, Mr. Hart, which is 50 pages or 40 or 50 pages long, extremely detailed. But we also produced to them, I'd like to pull up Exhibit 87, Plaintiffs 87.
Your Honor, just to be clear, okay. I wanted to point Your Honor to paragraph 24 of our answer.
Your Honor, I'm still responding to the.
And she needs to not share.
And can counsel pop off the sharing of screen because I can't show this exhibit, Your Honor.
Okay, let me end that.
And
okay, go ahead.
Which exhibit?
P87, please. So, Your Honor, here's another report. This is from a professional engineer. This is our second and third expert witnesses. This was also produced timely in accordance with your Honor's order and the Rule 11 agreement to the other side. Can you go to the next page, please?
You keep going. Next page. Next page. So as you see, Your Honor, any claim of lack of notice, lack of specificity, not knowing what the defects are in this case are just meritless. There's no basis for any kind of claim that they didn't receive timely notice and an opportunity to inspect. And I would point out, Your Honor, as you can see, they had full reports from our experts, from these experts, prior to the date that they had the right to inspect. And they never did it. And with regard to the reference in the Rule 11 about a right to re-inspect, we were never contacted. I was never contacted at any time as lead counsel for the Zatoons with a request by counsel to re-inspect. So they had two opportunities. They exercised neither one. And now here we have another effort to delay this trial. I think for all those reasons, Your Honor, this motion should be denied.
Your Honor, may I respond briefly?
Sure.
Two things. First of all, we haven't heard from Mr. Ackles, and if I can share screen, I'll show you that the declaration from Mr. Suster specifies that it was Mr. Ackles who refused to allow the inspection during the time in which predecessor counsel was seeking the inspection. Give me just 1 second and I will pull that up.
I believe that was with regard to settlement negotiations.
Absolutely it was, and that's what the act is all about. The act specifically, as it specifies in the act, it is to encourage settlement negotiations. Obviously, I'm not trying to settlement discussions are admissible. They're just not admissible to prove up liability. And that's not what we're doing here. Paragraph 2, Mr. Suster says, I had telephone discussions with opposing counsel for the Zatoons, Joe Ackles, regarding this case and for resolution of the parties' dispute. I requested the opportunity to inspect the property made the basis of this suit located at the address with my clients to evaluate the condition. There's no follow-up from him to inspect, nor did the Zatoons indicate they would allow it. And then I've attached all of my emails where I'm following up over and over, asking if we can inspect the property. And Mr. Scott was on all of those emails. So I think it's inaccurate for him to say that those requests weren't made to him, because I specifically made them. You can see here they see no need for one. And I say, I understand you see no need for one. My client needs one. My client says they need one if they're going to consider making an offer. So that's one thing, is that we have a declaration.
Ms. Pettit, let me ask a question, and I admit I think this is probably a good idea. It should have happened months ago. All of this stuff, but do you have an inspector to even do the inspection, or who would do the inspection? What exactly is your?
Yes, our request is that the builder do it. The builder is the one who gets to make the offer. And before I get there, paragraph 23.
The builder is your client, correct?
Versailles. Versailles is the one that has been seeking the inspection so that they can see what these alleged damages are. Certainly, I understand the other side has their own experts who say what they say, but it's the builder that has the right to inspect the property, make a record of it, and make an offer. And if that's reasonable, then the other side is held to it when it comes time for trial. Under paragraph 23 of our pleading specifies that we're talking about Texas Property Code section 27.004. And we say that we didn't, and Mr. Scott just said this has never been pled, but it has. I know it's in the Fourth Amendment.
That's only notice, not inspection that's pled.
I understand. I can read what's in paragraph 20.
And the case you cited said notice isn't required in the counterclaim.
Your Honor, paragraph 23, we plead, Versailles Chami deny that all conditions preceding to the Zatoons recovery have occurred or have been performed, satisfied, or waived. And this is a verified answer.
It's only verified, Judge, if you accept their Fourth Amendment late filed answer. The previous answer was not verified, and that's a critical issue here. They filed this answer on December 29th and put a verification on it because there wasn't a verification on the prior filed answer. And the court put this case in amber on December 8th and they're trying to get something in at the last minute as per the usual. And never mind the fact that the deadlines in chapter 27 of the civil practice of the property code gives them 60 days to inspect, and that's long been blown by. We gave them the expert report in January. They sign an agreement to inspect by April 30th, and they don't do it. And when they hire new counsel says, hey, we want to start all over. We want to inspect. And the answer is no. The deadlines have run. Our agreements have expired. We're not going to allow that. This case needs to go to trial.
All right, guys, don't interrupt me at this point. I want to ask some questions. So first off, Ms. Pettit, I'm strongly inclined not to do this because I think it's too late. But one thing I'd be willing to consider, I'm sure the other side is not going to like this, is to allow an inspection today and allow you to make an offer today. So my idea possibly is to allow opening statements to occur, let your client go inspect the property today, make an offer, and if it doesn't work, then start the trial tomorrow. I don't know that that would be helpful. I think you've blown your deadlines on this, but I do want to facilitate settlement if that's even a possibility. But I'm very concerned that this is just a effort to delay, which has happened quite a bit in this case. And I understand it's probably frustrating from your standpoint that stuff should have happened a long time ago from predecessor counsel that never happened, but you jumped into this case at the last minute. So would it be useful to do that, or is that not something that would be useful? We should just go ahead and go forward with trial.
I would say, Your Honor.
I'm not asking you. I'm asking Ms. Pettit.
Your Honor, I would ask that I give my client a brief moment to send me a text message if that's something that that they're willing to do. If they think that they can get that done today and make the offer, I imagine they can. I mean, they've looked at the list of defects already and have represented to me that those defects are minor in the scheme of things. We're being sued for $6 million in this case, so I'm confident that a reasonable offer is going to be less than that. So I know Mr. Alchami is on the line if he can. One thing I do want to let Your Honor know while I'm waiting for a text from Mr. Alchami, who just told me, yes, he'd love to go look at the property today. One thing I want to know is we've made diligent efforts, Mr. Zarilla and myself, to locate any case law that says that there's a waiver by delay on behalf of the builder, because that was my concern too, if somehow we've probably waived this. We have done a diligent search, and as of right now, we cannot find any case that says we waive it by not bringing it up earlier. So we've looked. I'm not saying there's for sure nothing out there. I'm just representing to Your Honor that we've looked and have found nothing at this point. My client says yes, he wants to look today at the property so he can make an offer, and he wants to make sure that the court would allow me to go with him to that inspection.
I'll respond to that, Your Honor.
May.
Your Honor, we think this is nothing but a show so that Mr. Alchami can improve on his testimony challenging the defects of the property, that he's going to use this inspection to do what he waived and didn't do by hiring experts to look at the property, so that he can testify at trial. These defects aren't really there. Here's my opinion about these defects. As long as he can't use anything, we don't want him to be able to use anything that he might see or opine on this, if this inspection is allowed at trial.
Your Honor.
That's fair.
Your Honor.
No, Ms. Pettit.
Your Honor, I think that the purpose under the act is for us to be allowed to make a reasonable offer. So I think that to the extent that we're allowed to make a reasonable offer, and Your Honor has the ability later on to decide if that's a reasonable offer, I think that's fine. My client should still be allowed to testify about all of the work that was done, during the build process and the photos, things like that. But we can agree.
What I think the concern is, and I share Mr. Ackles' concern here, which is I don't want this to be a situation where your client goes out there, takes pictures, and then uses that to bolster his testimony in this trial. I think that's a very legitimate concern that Mr. Ackles has. That's not the purpose of the act. And you jumped into a situation where there should have been an inspection months and months and months ago. I understand COVID and all that other stuff, but there was never, as far as I know, never any argument made that, hey, look, we couldn't get the inspection done because of COVID. We need additional time. None of that was ever done. And so
we can agree to restrict my client's testimony that when he is on the stand during this trial, he won't talk about what he sees at the property today. And we're not trying to delay this at all. We are here. We're ready to go. We're ready for opening. We can do this after court today. It doesn't have to be right now. We're ready to go. We just do want to make sure that my client is protected under the act, since this says false squarely within it.
We still oppose this maneuver by the other side. There have been settlement offers provided to us even as late as last night. They're just unacceptable. And I don't see any way that the inspection will change anything. To me, it's just nothing but a delay tactic on something that should have been done a year ago. And hasn't been done since then. But we oppose this. It's just delay. And given that it's my clients feel violated to begin with, to have Mr. El Chami go back into their home, that's and they've got small children, that's a problem for us. And I'm certain my clients can't speak on the subject, but we don't want this to happen because it serves no real purpose other than to help the defense.
I see two options here. We can do it my way, or I can reset the case. Mr. Ackles, what is your preference?
Door number one.
All right, let's do that. I'd envision we just do openings and then start off with there's a witness, I don't remember who, Miss Azimi or Azidi, I think, that's going to testify at 9 a.m. I'm willing to I do want to do opening because I want to be able to get to Miss Azidi if the case doesn't settle. But what is y'all's preference? Do you want to do more testimony than that? Is there a witness that has to testify today and is only available today, or how do y'all want to do this?
Your Honor, my understanding is that the plaintiffs are calling Mr. Zatoun first. So we're ready to go if we want to do openings and start Mr. Zatoun, and then do the inspection after Your Honor recesses for the day. That's perfectly fine with us, but I defer to Your Honor and opposing counsel if they have a strong preference otherwise.
Your Honor, we would suggest that we open and we use the rest of the afternoon to try to work out the logistics of an inspection, of course, without waiving our position that it's not under the Residential Construction Act. Yes, it is. There is no one that is only available this afternoon or today to testify.
I just want to make it clear to defense counsel that I'm going to allow Miss, I can't remember, how do you say the person's name that's calling in from Spain?
Izzadeen.
Izzadeen?
Izzadeen.
Mr. and Mrs. Izzadeen will testify at 9 a.m. tomorrow. So that means I don't want you to come in and try to argue Zatoun's need to testify before them. They're going to testify at 9. So does that change your position, Mr. Scott?
Not at all, Your Honor. We understand.
Okay. That's perfectly fair, and I appreciate that, Mr. Scott. So we're going to do openings, and then we're going to break for today. You guys are going to do your inspections. Ms. Pettit, I will say that your credibility is on the line here. If there's not an increase in the offer made, the court is going to be very, I'm not saying that, I'm not going to hold it against you if the case doesn't settle, but if you go in there and there's no increase in the offer, I'm going to be, anyway.
Your Honor, if I may clarify, so just, and I'm not going to tell you what the offers are, of course, it's not admissible facility in any event, but the offers we've made so far are to buy back the house. The offers that we want to make under the Construction Liability Act is to repair the house. So it's going to be a different offer because we have.
Okay, that's fair. That's fair.
But Your Honor,
I just don't want you to go in and then say, anyway, you understand where I'm coming from.
I understand, Your Honor. It'll be a different offer.
Okay.
Well,
all right.
This is the problem, Your Honor. An offer to let the fox back into the hen house to repair it, that's just not going, that's the non-starter. And so it's a futile exercise here.
Well, respectfully, Your Honor, the act allows us to make that type of offer.
See, that's the problem. The act says do it in 60 days after you get the notice of the lawsuit.
Is the property been fixed at this point or not? Or what's the status of the property? Is it still damaged or?
It's still damaged. It's not been fixed. It floods. We've got problems. And we've got
If they agreed to pay for somebody else to do it, maybe an agreed upon builder or contractor. I mean, I'm not trying to mediate this, but I do agree with Mr. Ackles that if the idea is that your client wants to go in and fix it, I can see why they wouldn't want that. So they may want to think about maybe agreeing upon a mutually agreeable contractor to do the repairs or something like that. Anyway, just a suggestion.
Yes, Your Honor. I understand Your Honor's concern, and we'll make sure that's addressed.
Okay, so how long do y'all want for openings?
Your Honor, you set that as 30 minutes per side.
30 minutes. Okay. All right, we'll go. Are you guys? Yeah, let's go ahead and start 30 minutes per side, and we'll start with the plaintiffs. And Miss Kreider, if you can go ahead and keep time. They have 30 minutes.
Your Honor, I'm just waiting for our PowerPoint to come up.
It's up.
Oh, you see it? It's not showing up on my screen for some reason. I'm sorry, Your Honor. Okay, that's fine. Good morning, Your Honor. May it please the court. Jonathan Scott, I'm lead counsel for Aaron and Jordan Zatoon. I want to say, Your Honor, that my clients are so grateful that we finally reached this point where we get our day in court and the court gets to see that this is not a garden variety home builder, homeowner dispute in which there's some disagreement over a few items on a punch list. Our punch list, Your Honor, which you will see during the trial, was 145 items. It was given to the builder when they were originally represented by Glass Phillips, the first set of lawyers, and they never repaired any of the problems. But the problems start at the beginning. And so the beginning is there's a relationship in which the Alchamis have described the Zatoons as being their family. They express to them repeatedly, trust me, we love you. Dylan Alchami, you're my brother. And so they created a fiduciary relationship, a relationship of trust. And as a result, my clients relied upon them from beginning to end. They only realized that they had been had or taken advantage of when in an exhibit that defense counsel has actually put forward, exhibit D33, on December 8th, 2018, after they were sued by the builder under a supposed promissory note, a phony promissory note, the evidence will show my clients retained me as counsel and visited the City of Dallas Building Department to find out for the first time that contrary to the representations that were being made to them and to a federally insured bank, Prosperity Bank, the construction lender, there was no certificate of occupancy ever applied for. There was no certificate of occupancy ever issued. And they also saw that the city revoked the building permit. So we have a situation in which this house that our clients paid more than the $507,000 contract price was delivered with 145 defects that the builder never made any effort to repair, that he's told this court in affidavits that he made an agreement in which he would know that the 1-year warranty that was in the builder contract, that was somehow waived or released by an oral agreement in June of 2018. And it's just a series of lies and fabrications. So, Your Honor, on this screen here, at the bottom, you see what the house is that the builder actually delivered. A smaller 1-story house that looks nothing like the rendering or the plan that was promised to the Zatoons at the outset. And so so this trial, Your Honor, you will see and the reason why there's a huge number of exhibits is these are exhibits that reflect an ongoing narrative, a false narrative about how much this project cost, whether the builder was out of pocket. And Your Honor is familiar that you made clear and unequivocal discovery orders that among other things, that the project file and the financial file was to be produced in full. Neither one was done. So instead, you'll see all kinds of emails, self-serving emails making assertions by the builder. And then they were so convincing, Your Honor, in their false statements that they caused our clients to write emails, which they're now saying is somehow in lieu of proof. But this case at base level or at a broad level is the difference between fact and fiction. And we are very comfortable that as the fact finder, you will sort that out. So, Your Honor, in the beginning, as I've said, the Versailles and the El Chamis leveraged their relationship with the Zatoons by promising construction of a 2-story dream house at a fixed price, at cost, all based on a rendering. They thereafter entered into a March 2nd, 2016 residential construction contract that expressly provided that it was a fixed price of $507,000. And this was the only thing that approximated the details as to what the plan would be, the home that they were going to get. Thereafter, the builder's draftsman, the Baskins, drafted a plan that's consistent with this rendering that I've showed Your Honor, even though it had not been drafted at the time the contract was signed. So this is what the clients were promised. This is what they were expecting. So on the fiction, Versailles and the El Chamis changed the plans to a smaller 1-story house based on the falsehood that the city of Dallas said it was impossible. And I'm talking about the city of Dallas Building Department, Your Honor. They're asserting in this litigation by affidavit that the city of Dallas said it is impossible to build the original 2-story house on the property. And that assertion, Your Honor, is based upon their narrative. I would note that a most relevant person that would be called if you wanted to corroborate that that a city inspector or city official in community development had ruled that plan was impossible and that you had to build a smaller house or a 1-story house, that the city of Dallas inspectors would be on the defendant's witness list, but they are not. Here, Your Honor, as I said, here's the excerpt of the affidavit or the declaration by Dylan El Chami, in which he claims that there was an impossibility. So subsequently, the city of Dallas refused to approve construction of the 3,777 square foot 2-story home originally planned and upon which the party's contract was based. Now, the contract, Your Honor, required that any changes in scope or in price be evidenced by written change orders or a written amendment that signed by the Zatoons. That never occurred at any point during this case. This is just a side note here. Your Honor, the evidence will also show that Mr. Alchami's affidavit is a further falsehood because the reference to 3,777 square feet, the house was more like 4,800 square feet, the design that was done by their draftsman. So I don't know where this reference comes from, but I will represent to the court that the plan set that our client received as the first plan set to be filed with the city was much bigger. But I also will draw your attention to the fact, Your Honor, that we have one of our exhibits is the certified City of Dallas permit file. And in addition to the fact that that permit file shows, and that's certified, in addition to the fact that that permit file shows that the building permit was revoked and that there is no entry for a certificate of occupancy, and that almost all of the inspections for the work that was done, they were green tagged, meaning they were initially approved to continue moving forward. But final inspection on all of the different work never took place. The builder did not do it. And again, they're raising this claim that city impossibility, that's going to be only based on the credibility of their statements. And there is nothing in any of the exhibits from the City of Dallas or any witness that in any way corroborates that this has any shred of truth. And Your Honor, I think there's a very good reason, as I'm about to show you, to seriously doubt anything that Dylan Elchamy or his father, Sammy Elchamy, represent to you, or any documents that with chatter or assertions that are the primary exhibits being relied upon by by adversary counsel, by Ms. Pettit. And what I want to make very clear, Your Honor, is the Elchamys and Versailles Dallas, I consider to be Ms. Pettit to be esteemed counsel. She's a very qualified lawyer. We all are qualified lawyers, so nothing I say is any way a comment about counsel's performance. But she, Your Honor, represents clients that are liars, perjurers, and financial predators. Before construction even started, Versailles and the Elchamys began drawing money from Prosperity Bank, federally insured financial institution, and they set into motion a series of inflated draw requests. And during the trial, we will show you many, many more, but I just want to give some examples that started literally from the outset. As I referenced before, the City of Dallas certified plan file or permit file reflects that the plan review fees by the City of Dallas were $300. Fiction, Dylan Elchamy swears to Prosperity Bank, and I will show you these exhibits in a moment, this evidence, that the cost is $5,200. Here, Your Honor, are the building permit applications filed for my client's property, signed by Dylan Elchamy.
What exhibit number is this?
This is exhibit P6. It's marked, Your Honor, right on the slide to the left. I don't know if Your Honor can see it. So the source document, this is P6.
I don't see it.
City of Dallas file. It shows the plan review fee on the initial application, $150, and then a second plan review fee of $150. And now let's look at what they submitted to the federally insured financial institution. This is the construction lender. This was prepared by Dylan L. Chammy, and you can see his signature. So he says here, which we've highlighted, undisclosed line item, City of Dallas review. And so here we have, Your Honor, already at the outset, they're setting up this false paradigm of expenses that weren't budgeted that are going into this project, out-of-pocket expenses for doing the work. Here's Versailles' quote unquote invoice that was attached to the application to Prosperity Bank. Says City of Dallas plan review, $5,200 instead of $300. And they drew out this money, Your Honor. So they're drawing under the construction agreement dated March 2nd, 2016. This was set up in which clearly and unequivocally it provides that the funding for the building of this house, the builder was to be paid in progress payments by construction draws. So my clients were never supposed to be asked to come out of pocket or to pay additional money unless they pre-authorized a change in the scope of work in writing, and that change in scope of work and the cost thereof was prepared by the builder and signed off. And as I've represented to the court, the evidence will show that never happened. Your Honor, part of our evidence in the case is going to be that this $5,200 overcharge and this bait and switch with regard to the house that was being built for my clients under the contract. These are just two examples at the beginning. And I can't possibly, in the 20 minutes time that I have to give Mr. Ackles 10 minutes, can't possibly go through, but we will during the trial. These are bookends. We will show the court many, many scores and scores of additional examples of fraud and illegal behavior and defrauding financial institutions, filing false instruments with the building department. And we'll get into that into some more detail when I have some more time. Your Honor, in April and May of 2018, so here we are on the back book end of the project, the bank, Prosperity Bank, is asking the builder, what is the status of the project? Is it completed? And there's a $40,000 final draw, and the bank wants a representation and an assurance that the project has been done, and is asking the El Chamis, what is the status of the certificate of occupancy? They want to make sure, before it makes sense, and to protect the Zatoons and themselves, they want to make sure that the house is complete before they make the final payment. The fiction is April 10th, 2018. This is another fiction. Versailles and the El Chamis file a phony mechanics lien in Dallas County, claiming $76,000 in extras. But the contract, Your Honor, states that they cannot get paid more than $507,000. And Your Honor, I would point out, it's not only the March 2nd, 2016 builder agreement between the El Chamis, Versailles, and my clients, the Zatoons, but on April 5th, there was an assignment of that contract to Prosperity Bank as part of a mechanics lien. And the El Chamis made the same promise and representation to the bank, which they completely dishonored, which is another lie on their part. 1 year later, an inspection uncovered 145 defects, revoked building permit, no certificate of occupancy was ever applied for or granted. Your Honor, here is as I alluded to, here's a series of correspondence between Parimal Patel, an officer at Prosperity Bank that we have subpoenaed to testify here. And he's asking, as I've indicated, what is the status of the CO? And you can see, and also what is the status of the house in terms of the construction. And so you can see Mr. Sam El Chami representing to this federally insured bank that the CO is in the works. But what the evidence will show is that there is no application for a certificate of occupancy ever submitted to the city of Dallas. And so this is just an outright lie, fraud, one of many. And you'll see also, Your Honor, further down the screen here, Mr. Alchamy is arguing and saying that he wants his $40,000 and that the CO is never a condition of the construction draw, but he's not trying to be difficult. I'm staying in my lane as always. I just want what's right and what's agreed upon. And I think the evidence will show, and has already indicated, these people do not do what is right. They say a lot of things. Again, here's a blow up of the May 15th. He tells the court, he tells the bank rather, the house is complete. That was also a falsehood. Now we have the mechanics lien that they filed on April 10th, 2018, under penalties of perjury, affidavit of mechanics lien by Dylan Alchamy, claiming that after allowing all just credits, offsets, and payments, the amount of $75,725.18 remains unpaid and is due and owing to claimant, and claimant claims a lien on the above described property, et cetera. So you can see Dylan's notarized statement. And again, Your Honor, under the contract, the only way there could be any extras or anything due and owing would be if there had been a signed amendment of the $507,000 fixed price. That never occurred. Now, Your Honor, let's look at what they've attached and filed with Dallas County property records as the supposed backup documentation for their $75,000 claim for extras. This is the invoice. Now, let me just go back for 1 second. So, Your Honor, you can see that the mechanics lien filing, oh, sorry, what happened? I pressed forward instead of back. Sorry, Your Honor, 1 second. So you see this mechanics lien filing was filed on, can we blow this up, Rob? Okay. This mechanics lien filing was filed and we'll
We
get
have
it.
10 minutes left.
Okay, Your Honor. This mechanics lien filing was filed on April 10th, 2018, claiming $75,725.18 is past due and owing. That's the representation. Here's the support. An invoice which was generated on April 10th, 2018, the same day as the mechanics lien, that my clients will testify that they never were tendered an invoice for this amount or any other amount. So this is a fabrication. And furthermore, Your Honor, it says that the due date, and this is in the Dallas County filing, says that the money is due on May 10th, 2018. So the affidavit and this document cannot be reconciled with each other. And as you see, there's one line item, furnished home all items paid by Versailles. And Your Honor, the evidence will further indicate that under Chapter 162, the Alchamys are trustees of the funds that they were receiving for this residential construction contract. We have never gotten bank records whatsoever or anything that shows that they acted as the trustees and did what the statute requires. Here, as I've indicated before, Your Honor, in the mechanics lien contract to the bank, the contractor made the same representation, and I want to highlight, any alterations made without a written agreement will be considered performed under the original contract at no additional charge. So here they are again, making another promise that they're going to stick to the fixed price, and that if they go out of scope or alter the scope of the project, they are going to not be able to claim additional money. Your Honor, this is from the City of Dallas building file. We talked about this before, indicating that the building permit, the master permit, was revoked January 17th, 2019. Then, Your Honor, with regard to claiming more money, May 17th, 2018, they sign a release agreement, the El Chamis and Versailles, with Prosperity Bank, acknowledging that they've been paid in full and they release all claims and mechanics liens rights. Based on that, they received 4 days later a $40,000 payment from Prosperity Bank as payment in full. June 14th, 2018, the evidence will show they still refuse to release the lien. And they create a fictitious promissory note, which lacks consideration. Here's the release, Your Honor. Extremely broad. I know, Your Honor, I won't read it because Your Honor has seen it in the.
I've already ruled on all this stuff, haven't I?
Yes, 40,000 paid. The promissory note, fraudulent promissory note. Then, Your Honor, as I alluded to before, I said to the court that neither Dylan nor Sam El Chami have any credibility, and that's what their case stands or falls on. So November 16, 2020, Your Honor, they filed an affidavit in support of a motion for a jury trial, and he claims that he never waived his right to a jury trial in the case. He claims that they never waived the right of Versailles Dallas to a jury trial in the case. December 8, 2020, that I'm not sure, that may not be the correct date, but in open court, we had I think it was on December 8th, there was we had the colloquy with counsel in which, in front of Your Honor, their lawyer, Israel Suster, waived a jury trial on behalf of all of them. But it goes further. Here's his affidavit saying
Mr.
those.
Scott, you have 5 minutes left. I thought you were going to reserve some
Okay.
for Mr. Ackles.
Absolutely. And here's the contractual jury trial waiver, Your Honor, that they concealed from you, dated June 14, 2018, in the very promissory note that they sued us on for a period of 2 years. I pass to Mr. Ackles. Thank you, Your Honor.
Mr. Ackles, you have 5 minutes.
We can't hear him. You're muted.
Thank you, Your Honor. May it please the court and counsel. I'd like to point out that the big picture is we have seasoned veteran home builders taking advantage of a young couple about to have a child and using their savvy and sophistication in business tactics to take full advantage. As Mr. Scott pointed out, the El Chamis and their company Versailles use cultural ploys, calling him family, treating him like a son and a brother, and at all times saying it's your family, we're going to do this for you. They promised to do this contract at no profit, and they put that into their statements to this court. They did this at no profit. Secondly, they used the threat of a bank foreclosure. The interim loan to build this property was scheduled to end in April of 2017, a year after it started. As it got close to April 2017, the bank started saying, we've got to refinance this into a permanent loan. You've got to get this house complete. The house wasn't near completion. That's when the El Chamis put the full court press on the Zaytuns. What they did was they said, you've got to pay this. They put the mechanics lien on the property. And the bank started threatening foreclosure. We've got a mechanics lien. This needs to be resolved. Young couple, the Zaytuns started being very concerned. What do we do now? Who did they turn to for advice on how to remedy this but the El Chamis? And the El Chamis solution is find another way to pay us. And they used the pressure of the foreclosure to force payment. So they, as you know, Your Honor, they came up with this promissory note that didn't have any consideration, and they got Jordan to pay the $14,000 down payment. Put that slide up if you don't mind. Jordan writes this check to Sam Elchami in June of 2018 to pay the $14,000. What the evidence is going to show is that at the time he wrote that check, there was $40,000 in that account. If some things happened after that, that check did not clear when it was finally deposited by the Elchamis. Next slide, please. And what happened was, after that, Jordan paid the Elchamis over $56,000 to cover all that. This is money extracted from Jordan and Aaron Zaytoun by the Elchamis because they kept demanding, pay us more, pay us more, pay us more, or we're not going to release a lien and the bank's going to foreclose on you. In addition, they used their position as real estate players to force the Zaytouns to pay them, or Jordan Zaytoun to pay them out of real estate commissions he obtained on sales of other unrelated houses. This is part of it. You'll note this says Tulip. That's a house he sold on Tulip. They took part of his real estate commission because they kept saying, if you don't pay us, we're not going to release the lien. The bank's going to foreclose on you. And then, of course, they concealed. There were actual physical and mental threats on the Zaytouns. Next slide, please.
You have 1 minute left.
Thank you, Your Honor. These are the threats. Next slide, please. Next slide, please. One of these, Your Honor, he says it's a felony because of that bad check, even though Jordan had paid him off. And they threatened to take him to the authorities. And in these emails, what happens is the Zaytouns all say to them, we're here to pay you whatever you ask. All these emails, we don't have time to present them all, Judge. We're here to pay you whatever you ask. We just want to get this done. This moment, I don't know what to do. He's begging them for help. What do I do? And all the times the Elchamis say, pay us. The bottom line is, Judge, this is the trial like most trials. It's about truth. What is the truth? And the facts relayed by the Aaron Jordan Zaytoun are going to be the same as they've relayed them from day one. The facts related by the Elchamis are going to change as they have changed for 2 or 3 years and as they have changed in their filings with the court. If we accept what the Elchamis say, they've committed bank fraud by misleading the bank through all these practices. Bottom line is, Judge, this proceeding will define the truth. When the truth is decided, we will be asking for punitive and exemplary damages, and for you to deter this kind of conduct from this company in the future. Thank you, Your Honor.
All right, defendants, you have an opening.
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel. Mr. Scott represented that I represent liars, perjurers, and I think he used some other words. But I want to let you know, Your Honor, that I'm here today and I'm proud to represent Versailles and Mr. Elchami, both Elchamis. I only wish that I had met them earlier, but I'm proud to be here now at trial and representing them here today. Your Honor, this is a case based on the phrase, no good deed goes unpunished. And I think that as we go on, you'll see that this is certainly the case between the Elchamis and Mr. Zaytoun. Let me tell you what this case is about. First, I'm going to go over who the parties are. So first, Mr. Sam Elchami is the father. He is one of the owners of Versailles, he's the secretary of Versailles, and his son Dylan Elchami, who is the president of Versailles. And together they build custom homes here in Dallas. Mr. Zaytoun became a friend of Dylan Elchami. Mr. Zaytoun is a very experienced real estate agent. He has more than a decade of experience buying and selling homes. He prides himself in selling $50 million plus in real estate. So this is not an unsophisticated party. This is someone who prides himself in his $50 million plus of properties that he sold. So along the way, Dylan and Mr. Zaytoun become friends. They become very fast friends. And of course, Dylan is close with his dad. So Jordan kind of comes in on this relationship with the Elchamis. Mr. Sam Elchami, he liked Mr. Zaytoun. Mr. Zaytoun seemed pretty eager in the real estate industry. And so Mr. Elchami kind of became more of a father figure to Mr. Zaytoun. Mr. Zaytoun would say that Mr. Elchami was his mentor and that they had this mentor relationship in real estate. Mr. Sam Elchami would show Mr. Zaytoun the ropes in real estate. And Mr. Zaytoun made a lot of money over the years based on relationships and deals that Mr. Alchami would bring, and they would do deals together. Mr. Zatoun and Dylan Alchami called each other brothers. That's how close they are. Now, Mr. Zatoun watched from a distance for years and years while Sam and Dylan were building these custom homes in Dallas. He had seen firsthand the type of work that Versailles was doing. So when he wanted to build a house for himself and for his wife, he approached his mentor, Sam, and asked Sam and Dylan for their help. See, in Texas, if you're getting financing, you can't actually be your own builder. You have to have a builder on paper. And so Mr. Zatoun asked for a favor from the Alchamis. He said, would Versailles be the builder on this home that I'm wanting to build? And Sam and Dylan, being the nice guys that they were, said, sure, your family, we're all friends. We'll do that for you. You can put Versailles on the contract. That's just fine. So he was the builder. Versailles was the builder, but Jordan was going to be the one that runs the project. Like I said, he's a very, very sophisticated real estate investor. This was a no-brainer for Sam and Dylan. They were like family, so they quickly did the contract. Here's a picture of the house that we're talking about that you've seen. Now, because Mr. Zatoun was like family, Sam and Dylan agreed to be the builder, just on paper, like Mr. Zatoun wanted. They had agreed from the very beginning with Mr. Zatoun that they were not going to make a profit on this. They were just doing this as a favor for Mr. Zatoun. And what they agreed to do was introduce Mr. Zatoun to their contractors and people that do work for them so that Mr. Zatoun could run this project just like he wanted, and so that he could build this custom home. Now, the $507,000 is important because that $507,000 was the maximum loan amount that Mr. Zatoun could get. So they started off with a loan amount and then had to back into this contract with the bank. Here is the agreement between Mr. Zatoun, his wife, and Versailles. It's signed in March of 2016. Admittedly, the contract says that changes have to be in writing. But Your Honor, during this trial, you're going to see email after email and text after text that each of these changes were made and that Mr. Zatoun and his wife were intimately involved with each and every change, every step of the way. Additionally, there's a mechanics lien that was signed in this case, which counsel showed you. It's our Exhibit 30. The mechanics lien deals with what happens when a homeowner, like Mr. Zatoun and his wife, want to make increases or alterations to the plan. Paragraph 2 says, if owner and contractor agree in writing to alter plans for the construction, on completion of the construction, owner will pay for all extra work done and material furnished as a result of the alterations. So because everyone knew that the Zatouns would be the ones on the hook for any overages, the parties went on and Versailles just simply wasn't concerned about it. Everyone knew that alterations are going to be paid for by the Zatouns. So once the contracts were signed and the plans for the home got started, Sam and Dylan were informed that Mr. Zatoun's lot that he told them he wanted to build on was actually 3 lots. Well, that doesn't seem like a problem. It's actually a huge problem when you're going to get things approved from the city because platting is different. This was not platted as 1 lot. It's platted as 3 lots. And the testimony will show that the initial plans became impossible because Versailles had never been informed prior to the contract that this was actually 3 lots. That is what started an extensive revision process. That's why the Baskins will testify about the 4 plans that they had to do, because it took 4 sets of revisions to finally get this approved from the city. Everything changed once Versailles was informed that these were 3 lots and not 1. It went from a smaller 2-story home to a much, much larger 1-story home. And as Your Honor is probably aware, 1-story homes are actually much more expensive to build because you've got such a larger foundation. So if you've got the same square footage in a 2-story house, the 2-story house is far less expensive than a 1-story house because you've got so much foundation on that 1-story house. Your Honor, you'll see emails from Mr. Zatoun during this time making changes to the plan himself, wanting additional bedrooms, for example. He was part of all of the changes and alterations that occurred in this case. There's not 1 change or alteration where you're going to find he didn't approve. Your Honor, you'll see that each step of the way, the Zatouns acknowledged and supported the revisions and these plans. They never once took the position that these revisions should not be made. They wanted each change and requested many of them. So as I mentioned, this contract was signed back in March 2016, and by September 2016, the city finally gave them a master permit. But obtaining the master permit is just part of finalizing the plan. When you change the entire outside of the design, then you have to go back and relay out the inside of the home. As of 2016, in the fall, there's still a ton of plans that have to be done for the interior of the home. At that point in time, from as early as September 16th, the Zatoons are acknowledging that there are tons of extras that have already been incurred. And as we know from looking at the contract, the extras are paid for by the homeowner. Here's an email from Erin Zatoon from September 29th of 2016. She's saying tons of extra costs have occurred. This is really before anything has almost gotten started. They're acknowledging that they're way over budget. And as we saw in the mechanics lien contract, that's them. Again, Versailles was not worried at this time. First of all, these are their friends, they're like family. And each step of the way, everyone knew that Versailles was not making a profit. They were doing this as a favor for their friend, and the Zatoons were responsible for the cost to build the home, including overages. By January of 2017, Versailles had submitted the final version of the plans, which were finally approved in March of 2017. After that, so March of 2017, we've kind of got everything in place and construction went forward in earnest. Most of 2017 is fine. They're constructing the home. Mr. Zatoon, you'll hear, is out at the property almost every day, watching his contractors, watching everything that's being done, running his project, supervising everyone from start to finish. This was Mr. Zatoon's baby. This was his project. This is the home that he was building. By November of 2017, everyone was about to head into the final phase of construction. I know Your Honor is very familiar with construction financing, but I want to just talk about it briefly, just to make sure that we're clear on how the construction financing was working in this particular instance. So construction financing is normally a very short-term type of financing that's just in place while a home is being built. Here, Prosperity was the construction lender. They had given a loan for, I believe, $640,000. The first 113 of that was used to buy the actual piece of land, and that's where we get the $507,000 that was left for the construction. Under this type of construction agreement, Versailles, the builder, had agreed to pay all of the costs up front. So from day one, Versailles is in the hole because they're paying the costs up front. And then once work is complete, Versailles gets reimbursed for those amounts that they're being paid. So there is no bank account where Versailles just has $507,000 sitting around. They're being reimbursed once work is done and once that's approved. That process, Your Honor, is called the draw request process. So in this type of construction financing, there's a draw request. Versailles says, hey, we've poured the foundation. We want to be paid now to reimburse us for the foundation. And a couple of things have to happen. So when they want a draw request, the builder has to confirm that the work was done. The homeowner, so the Zatoons, have to confirm every step of the way that the work is done. And then many times you'll hear from the bank comes out and does their own inspection because they want to confirm that this work is done and that they're not going to overpay Versailles for work that isn't complete. This is a very structured process. This is something that banks do regularly and that builders do regularly. So again, in a situation like this, Versailles is only being paid for work that they say is done and that the homeowner agrees is done. Then once construction is complete and that $507,000 is paid down, that's when the homeowner goes and gets their permanent financing, which is the financing that they may keep for 30 years or less if they end up selling it before then. So back to what happened here at the end of 2017, Mr. Zatoon and Versailles are coming down to that last draw with Prosperity Bank. The home is almost complete and they're at the very end of the process. The evidence will show that everyone knew there were overages. Versailles had paid all of these overages out of pocket. So Versailles is basically acting like a credit card for the Zatoons who didn't have money to pay for these overages along the way. All of these amounts were supposed to be reimbursed to Versailles. The Zatoons just needed to pay for them so that that lien could be released. Now, first, Mr. Zatoon thought that the bank would just increase the loan amount. So he went to the bank and said, hey, we're way over budget and the house is costing more. Will you increase and give me more money? Prosperity said, no, we're not going to increase it. But Sam and Dylan, being the nice guys they are, they said, well, let us talk to the bank. So they went to 2 different lunches with Prosperity and with Mr. Zatoon and said, Prosperity, will you give them some more money? Everything's over budget. They want these increases. They want, this and that. Will you increase it? And Prosperity again said, no, we're not giving you any more money. So the parties came up with a solution. You'll see a flurry of emails in November of 2017 when the parties come up with this solution. During that time period in November of 2017, my clients and the Zatoons reach an agreement that since Prosperity is not going to give them any new money, then this money that Versailles has been fronting on behalf of the Zatoons will just become a part of the permanent financing. So we're at 507 with the loan. You know, Versailles owed X amount, so we'll just get the new loan for larger than that amount, and it'll pay everyone off. It makes sense. It happens regularly in these types of situations. And again, Versailles is comfortable with it because they're going to get paid back. Everyone was aware of this plan. Versailles was aware. The Zatoons were aware. The bank was aware. The mortgage broker, Jason Boley, was aware. Everyone knew in November 2017 that that's what was going to happen. But fast forward to March of 2018, Your Honor, and you'll see another flurry of emails. By that time, the property is very close to being done, but there's still a ton of overages. Versailles is still continuing to pay the overages with the understanding that they'll get paid back. At this point in time, Your Honor, there's the $507,000 budget that's going on kind of on one track, but there's a separate parallel track where the parties are keeping track of all of these overages that the Zatoons are required to pay. So there's the 507 amounts, and then there's the extra parallel track of the overages. Dylan Elchami will explain to you, and Mr. Sam Elchami will as well, that they were keeping track of these overages in this long running spreadsheet. Let me find it 1 second. Actually, it's Exhibit 61. I'm not seeing on my.
Plaintiff or Defendant 61.
I found it. It's Defendant 51. I'm sorry, Your Honor. So here is the long running list of items that they were keeping track of in an email. And as of this date, the first part of this is added up. The second part is not. I'll do that at some point during trial. But the first part, I zoomed in the bottom. It shows Zatoons owe us around $60,805, and that is as of March 2018. So as of March, this is their running list. You can see that Mr. Sam Elchami emailed this to Jordan Zatoon, and Jordan forwarded it to his wife. There's no complaints. There's no, hey man, what are you talking about? We don't owe you anything. It's just, this is what they were doing. They were keeping track of every little line item that was above budget, and everyone knew that the Zatoons were going to pay that amount back. So as of March 2018, there's only $40,000 left in I'll call it the Prosperity track. And there's all these other overages that are in this other track that are being kept separately. And that's when kind of a big fork in the road happens. So there's $40,000 left in the Prosperity budget. Sam Elchami told Mr. Zatoon that this last $40,000 from the Prosperity budget has got to go for a driveway and to address the drainage at the property. So Sam says, we've got to have drainage and grading, and we've got to do a driveway plan. And he told him, you need a circular drive, because if you do a straight driveway with this house, all the water is going to go straight into your garage and your house is going to flood. So we've got to use this $40,000 wisely and do a circle driveway. But Mr. Zatoon had his own ideas. He didn't want that. He wanted a really cheap straight driveway because he wanted to use the extra $40,000 for a wrought iron security fence and for landscaping. So they have this disagreement, and Sam keeps telling Mr. Zatoon over and over, don't do the straight driveway. You've got to do a circular drive or your house is going to flood. But Mr. Zatoon wouldn't listen. Unbeknownst to Versailles, Mr. Zatoon took matters into his own hands. He went behind Versailles' back, contacted one of Versailles' subcontractors, Mr. Ramos, and he got Mr. Ramos to agree to do a straight driveway and a fence for a total of $40,000. But Mr. Ramos got the first $15,000 from this and disappeared and was not heard from again. So he took the money and ran. Everyone knows that you can't do a wrought iron fence on an acre lot and landscaping and a driveway for this cost. It's an expensive undertaking. This particular fence that Mr. Zatoon and his wife wanted for security is just not something that would have fit within that $40,000 budget. That was a line in the sand for Versailles. At that point, Versailles knew Mr. Zatoon has taken over the construction of the home. He's going behind our back. He's contacting our subcontractors. He owes us a lot of money, and we're starting to get a little bit nervous about what his plans are. At this point in time, by May of 2018, the property should have been finished, and there should have been a certificate of occupancy. Now, again, as of this time, May of 18, Versailles has not been paid back for their out-of-pocket costs, but Sam is confirming that everything is almost done with the property. At that point, the final electrical inspection has been done. And all they needed was the final building inspection and the certificate of occupancy. So we're all in agreement that as of that point, what we need is a building inspection and the certificate of occupancy. But once again, Mr. Zatoun is up to no good and messes everything up. In May of 2018, the evidence is going to show that that's when Mr. Zatoun's lease was ending. He asked Sam and Dylan, hey, can I move some stuff into the house? They were adamant. You cannot move anything into the house for a very important reason. You can't get a certificate of occupancy if the city comes out and finds out that there's stuff here, there's someone living here. That's just how it works in new construction. If someone's living in a newly constructed house, you will not get a CO. But Mr. Zatoun kept begging, well, can I just put boxes in the garage? And Sam and Dylan, being the nice guys they are, said this, look, if you want to put boxes in the garage, put boxes in the garage, but put tarps over them, tape them down, make them secure so that when the city comes out, there's no way they think you guys are living in this house. So Mr. Zatoun agrees. We will just put boxes in the garage and we'll tarp them down. Well, the next day, Dylan El-Chami goes out there and there's beds there. The Zatouns have moved into the house, Your Honor. There's no showers working because the water's not turned on. Apparently the Zatouns are going to the gym every day to take their showers. The electrical is not hooked up. They've moved into this house after they're told you can't get a certificate of occupancy if you do that. About this time, Mr. Zatoun drops another bombshell. This one's worse. He sends an email and informs everyone that that extra permanent financing he was going to get to pay everyone off, he's not going to qualify. You can see that in this first part of the email. I received word yesterday that I don't qualify for a loan over $600,000. Okay, so now they're living in this place with no certificate of occupancy, with no running water like it's supposed to be. He goes on, I know this puts the current home construction and more importantly, our relationship in jeopardy. This has always been a family matter. At the end, I promise to make things right with you guys and pay what I can to make things right with you both. Even with all of this going on, Your Honor, as of May 18, Mr. Zatoun is still admitting that all of the work has been done and that everything looks great. Look at this Exhibit 64. So he sends an email the same time period to the bank saying all of the work has been performed and looks great. This is Mr. Zatoun, the one that's now suing my client for $6 million, an experienced real estate investor, saying the work has been performed and looks great. And as of May 2018, Mr. Zatoun is still admitting that he owes Versailles for the overages. So here we are, same day, May 14th, Mr. Zatoun saying, I can't pay the line of credit to Sam and get into this loan, so I don't know what to do. Last sentence, I'm not trying to not pay you all you are owed. Everyone knows that the Zatouns are on the hook for this money. They admit it, Your Honor, over and over in emails and text over and over. Here's another one, same time period. This is from May 26th. He sends a text. This is with the real estate broker, Jason Bowley, Jordan, and Dylan. He says, we will get you the $75,000. You just have to trust us. Everyone knows that he owes this money. So he's in a bind, clearly. What does Sam and Dylan do? Because they do what they always do. They're going to help him out. Again, Sam jumped in and said, look, we'll make a way for you to get out of this mess. They sat down, they had a meeting at one of the other houses that they were working on, that Versailles was working on, and they came up with the exact total of all of the overages. They took the overages, and then I think Mr. Zatoun had given them a car that they sold to cover part of the overages, but minus the car, they're right at a $75,000 that's owed. They set up a series of 2 transactions so that Mr. El-Chami could help help Mr. Zatoun get out of this mess. These 2 transactions look familiar because I used the same slide in our motion to reconsider. So the first transaction is this, Your Honor. May 14th is when Mr. Zatoun tells Versailles that Prosperity is not going to give him additional funding unless this lien is released. So on May 17th, even though Sam and Dylan have to do so, they released the lien so that Mr. Zatoun could get new financing. They did not have to do this. They could have at that point said, nope, we're not releasing it. We need to get paid. Everyone knew at that point that this additional money was owed and they would take care of it as part of the second transaction. Here's the second transaction. Versailles and the Zatouns enter into an agreement that $76,000 is owed. That's what I just talked about. They have a meeting at a house and they come up with the number. They sign a new promissory note in which the Zatouns say they're going to pay $75,000. It comes in two ways. One is the $14,500 check, which I'll get to in a second, and the remaining amount was on a note. So combined, we've got roughly the $76,000 that's owed. And in exchange for that, Versailles signs a release saying we've reached an agreement. And I'm going to show you the actual documents now, but that's the second transaction. A new note, a check for a down payment, and a release of lien. And Versailles says, look, we'll do you a favor. We'll get paid later on it. Just get your financing in place. Here's the check that was given to Mr. El-Chami for the $14,500. Opposing counsel wants to make much of the fact that he had the funds in the account that day. But what's interesting is you'll hear Mr. El-Chami testify that Mr. Zatoun said, don't cash this check right now. I need a little bit more time. So I'm giving it to you as a down payment, but don't cash it right now. And you'll see the records reflect that he didn't. He did exactly what Mr. Zatoun told him. He held on to the check and cashed it later. It was hot. Here's the promissory note as part of the same transaction that Mr. Zatoun and his wife signed saying, you owe $61,500. They sat down, they agreed that they owed this amount. The third part of it, of course, is the release of lien, stating we've reached an agreement. So my clients agreed to release this lien, they didn't have to, in exchange for that promissory note and in exchange for the check. So of course, what happened? Check is hot because my client holds it like he's told to do. They never make a single payment on the promissory note. But Your Honor, even after all of this happens, so my clients know they have a hot check. My clients haven't gotten a single payment on the note. Even after all of that, the first big rain comes. And as I mentioned, Mr. Zatoun was adamant that he had to have this straight, cheap driveway that he was instructed not to do. So the first big rain comes. And what happens? The entire house floods, just like Sam El-Chami told him it would. He said, if you do a straight driveway, it's all going to flood. The first rain comes and it floods. But as you'll see, Your Honor, when you meet my client under oath, you'll see what a nice guy he is, that even after all of that, Jordan Zatoun sends him an email. Dylan, Sam, with the heavy rain, our home flooded last night. A lot of the hardwoods, almost all in the office, hallway, and leading into the living room are ruined. We don't have the money to fix it. It's really upsetting. There isn't proper drainage in the front. Water accumulates immediately as it starts to rain. I know it's not your problem. I'm just letting you know. Mr. Zatoun admits in writing after that first rain that he knows this isn't Versailles' problem. Your Honor, I can tell you this much. If I just paid for a brand new house and the house floods after the first rain, you better believe I'm going to say that it's the builder's problem. But that didn't happen here. Why? Because Mr. Zatoun knew that Sam had told him that this driveway plan wouldn't work. Mr. Zatoun knew he had taken over the project and that it was his own fault, not Versailles. What does Sam do? Even after he's received the hot check, he hasn't gotten paid.
5 minutes.
Sam, thank you, Your Honor. Sam runs out to the property and tells Mr. Zatoun exactly how to fix it. He shows him, hey, you can put a drain right here and we can still salvage it. Just put this drain next to the driveway and it's going to fix this. But Mr. Zatoun didn't want to do that because he said it wouldn't look good at his house. And again, all the way to this day, the Zatouns have refused to mitigate the damages and take the advice of their builder. So after a while, Mr. Zatoun blocks Dylan's and Sam's texts and calls. He won't make right on anything. And what's significant about the timing, Your Honor, is that the first time Mr. Zatoun ever makes a complaint about the quality of the build or complains about Versailles is after Versailles sues to collect on the notes. Remember, Versailles is the one that filed suit just to collect on that $75,000 and they got hit with these counterclaims. But the first complaint you will see, there's not a text, there's not an email that you're going to see during this trial before my clients sue, in which there's complaints by Mr. Zatoun or his wife about the quality of the workmanship. They're showing, Your Honor, these checks regarding properties like Tulip, and we'll show you during the case that those things simply aren't relevant. The Tulip one is actually kind of funny because that's a property that my clients owned. They did a favor to Mr. Zatoun, like the many favors they've done to Mr. Zatoun, and told him he could be the listing agent. And so there was a deal where he was going to give them back part of the commission. So Tulip, I mean, they can talk about all they want, but that's my client's property in which they did a favor and listed it with him. Other commissions, things like that, that's all the same thing. We'll explain to Your Honor why those are not relevant. Certainly they may show you pictures saying that the house looks bad. And you know, I haven't seen it, maybe I will today, but certainly it does. And that's because the Zatouns took over. They moved in before there was a certificate of occupancy. or there was running water. They caused the flood because of their own driveway design, and now they want to point the finger at my client. Your Honor, as far as their claims go, I want to just briefly address a few claims before my time runs out. The claim about the trust funds will show you that there was no misapplication because we were being reimbursed for those expenses we paid. The trust fund liability would come into place if we were holding funds, but that's not the case. We were simply being reimbursed for amounts that we had paid, so that's not going to apply. As far as the fraud and DTPA, Your Honor, those claims are demonstrably false, and we'll show you that, not to mention they'll be barred by the economic loss doctrine. There's simply no evidence to support their other claims, Your Honor. But I want to briefly talk about how important in this case waiver and estoppel are. Your Honor, we have a $507,000 contract that wasn't amended, but every step of the way, the plans and the budget were revised. They knew that, the Zatoons knew it, and they approved it, and they were actively engaged every step of the way in making these changes. They absolutely agreed that there were significant overages, and they knew they were responsible for it. They admitted they were responsible for it over and over. You'll hear Versailles testify and confirm that they've never made a single dime on this home, Your Honor. They were only doing this to help out their friend, when in fact, quite the opposite has happened. They've lost $75,000 plus in cash that they fronted for the Zatoons. And then they've been drugged through this litigation for the last 2 years, paying for lawyers to defend themselves in this lawsuit. For the Zatoons to now say that they were defrauded, Your Honor, that's why we have defenses like waiver and estoppel. You don't get a free house for making this sort of claim. Your Honor, like I said at the beginning, this is a case of no good deed goes unpunished. I thank you for your time, and we look forward to trying this case, Your Honor.
Okay, thank you. Thank you, guys. All right, so let's kind of talk about the schedule now. You guys are going to try to do the inspection, I guess, this afternoon and maybe settle the case. We'll see, hopefully. If not, then either way, I want you guys, at least lead counsel for both sides, to come. Even if the case settles, I'd like you to come back to this Zoom link tomorrow morning at 9 just to kind of announce on the record what's happened and kind of work things through, because I'm a little concerned with the history of this litigation that everything gets done correctly. So if the case does somehow settle this afternoon, I would still like to see lead counsel tomorrow morning. Any questions about the schedule and anything about this?
No, Your Honor, I'm just instructing that we coordinate amongst ourselves to allow my client and myself access to the property today.
Yeah, how do you guys want to do that? Or do you guys do I need to facilitate that, I guess?
I'm open to whatever Mr. Scott suggests. Obviously, we're open and available anytime today and can be out there whenever.
Mr. Scott? You're muted.
Does it say?
Your Honor, what I was saying is that counsel can coordinate this. We'll do it. We don't need the court to facilitate, but thank you.
Well, good luck. That was good opening statements by both sides, good PowerPoints and good argument. And we'll see you guys in the morning, one way or the other. It would be helpful if you guys let the court know, so leave a message with Rhonda if the case settles, just so we can, the court can make whatever other plans they need to make. And we're estimating this case is going to take 3 days to try. Is that right?
We had given an estimate, Your Honor, on our side. We said if we couldn't agree on the exhibits, that it might take 7 days to try. But certainly, our expectation is it's going to take between 3 and 5 days, especially. Hopefully we can get through it, but we have collectively we have over 200 exhibits that have been admitted.
I do want to point out a couple of things just to maybe speed the trial along. I've already ruled on this issue involving, you guys both discussed it in the openings about this promissory note. I've already ruled on that issue, so I don't know that we need to go into a lot of detail about that. So let's keep this focused on what this case is about. I would urge you guys to really, both sides to really try to settle this case. You know, I ruled on the initial summary judgment based on the contract with the bank. That doesn't mean that I've ever ruled that the El Chamis, besides that, did anything wrong. Now, maybe in trial that will come out, but there was a provision in that contract that said that was a full and final release. So I felt like the promissory note was released with that. But you know, that I haven't made any determination as to anything else. And so don't make any assumptions based on past rulings how I'm going to go in this case. So either way, and I hope it works out. And if not, we will see you. We will see you tomorrow. I will say that there will be some scheduling issues on this. I can try this Wednesday, Thursday, Friday, but next week I do have some scheduling issues that we'll need to talk about. So I would really urge you to think about, this is a non-jury case. You don't need to try this like you do a jury trial. I'm pretty familiar with the facts here, and you don't need to keep repeating things like you would in a jury trial. So, you know, just let's try to get to the point. I can rule on this pretty quickly, I think. So let's not, anyway. So we'll talk more about that tomorrow if the case doesn't settle. Good luck with getting everything worked out, and we will see you tomorrow.
Thank you.
Your Honor.